Hey, I have 10 a.m. So with that and the fact that we have reached quorum, I will call the February 4th meeting of the Vermont Criminal Justice Council to order. The first item, any additions or deletions to the agenda? Are there any to be offered? Hearing none, I'll entertain a motion to adopt the agenda.
So moved.
Moved by Sheriff Anderson, second.
I'll second it.
Okay, we have a second. Lindsay, are you ready with the vote? As a reminder, those that are council members on the system are able to vote electronically. Those that are not on the system vote through the chat. Okay, all of those in favor signify by, oh, it'll pop up. Sorry, Lindsay, pushing you. Okay, there we go. Poll is up. And in the chat, we have a few members that will need to vote that way. We appear good, Lindsay?
Yes.
We have approved the agenda for today. We don't have many updates for today, other than a reminder that the legislative session is fully underway. So I know many are busy, various constituencies in that regard. Just a reminder of our hearing date of the 17th, Tuesday the 17th. So keep that in your calendar. We'll have some more word about whether we're going to actually have a contested hearing or whether there will be stipulation on that. Can't answer that at the moment, but keep the date in your calendar firmly. I am going to move to the next item on the agenda, which is the approval of minutes. We have two meetings. One was the hearing of December 16th. We will address that first. I'll begin by accepting a motion to approve the minutes of December 16. Come off mute.
I'll make that motion, Mr. Chair.
Okay, thank you, Butch Shaw. Second, please.
I'll second that.
Okay, seconded. Any amendments, corrections, etc. for those minutes? I found none, but if we're satisfied with those as presented, then we will move to voting to adopt those minutes. And, I'll wait for Lindsay to get the vote up on the screen. There we go. Okay, same procedure. See them coming in.
Mr. Chair, while we wait for the vote, can I just pose a question?
Sure.
To process. With the vote, there's no ability to abstain. I needed to. I put it in the chat, which is what everyone else seems to be doing. That's abstaining. Could we add an abstention option in future meetings if that's something that needs to be?
We could. I'll have to scrub Robert's rules because Robert's rules is you vote yes or no, you just don't vote. So but we'll have to look at that a little closer. That's how I see you're reaching for it. I have mine here too.
I'll see if I can find the answer to that question and follow up with you.
See if you can find it. But having said that, it'd be easy to do. I'm speaking for Lindsay on this, of course. I think it would be easy to do. The second set of minutes is for January 2026. I'll entertain a motion. That was the January 7, 2026. Oh, we have 3 minutes. I'm sorry, we have 3. January 7. I'll entertain a motion to adopt the minutes of January 7, which was our regularly scheduled meeting last month.
So moved.
So moved. Second. Okay, I see Kelly. Kelly has
I'll
seconded
second.
that. Do we have any amendments, edits, changes that would be required? Okay, hearing none. Then Lindsay, if you could put the vote up, please. We passed those, Lindsay, by majority.
Almost. I'm waiting on a couple more. All set.
Thank you. And then finally, the minutes of January 20, which was the hearing from three weeks ago. I'll entertain a motion to adopt those minutes. I think that was Karen. Was that you? I can't tell. Do we have a motion to adopt the minutes of January 20th, please?
So moved.
Second.
So moved by Butch Shaw. Second. We have a second, please.
I'm
Are
the
we
second,
gonna-
Anderson.
Okay, Sheriff Anderson. Thank you, Sheriff Anderson. Okay, Lindsay. This is the hardest group to get motions out of.
While we're waiting for the response, it would seem a blank ballot would be the method through Robert's rules, Mr. Chair.
So I would add blank as an option. What does that mean for me?
According to Robert's
A
rules,
vote?
but I'll take this conversation to the Rules Committee and we'll just ignore my request for now, Lindsay.
Okay.
Thank you, Mr. Chair of the Rules Committee. We will do that. In the meantime, Lindsay, if we adopted the minutes of January 20. On the electronic record, there. Okay, thank you. The executive director updates are next on our agenda, and I know this has been a busy week for the academy with the new class coming in, but I will turn the floor over to Executive Director Chris Burkell.
Thank you, Chair. Welcome everybody to the council meeting today. I want to just bring up one thing before I get into my executive director updates, which is I had a member of the public suggest to me that our agendas might be a little bit more clear or transparent for the public's information. And I just want to make two notes on the agenda that we have today. After my updates, we have an agenda item listed as ECSD FIP policy. That is the Essex County Sheriff's Department's fair and impartial policing policy, which is on the agenda. And underneath that agenda item, we have a draft policy 20 VSA 2372, which is the model policy about sealed criminal history records. It was just made aware to me that for the general public that might not be familiar with the constant conversations that we have or repeated agenda items, that in fairness to them, we should be clear in that. So just taking that for note, so that we'll try to be a little clear in the agenda items as we list them. But I just wanted to be clear for today's agenda items as well, so that the public knows about that. So moving on to my updates. We, as of January 12th, started with our new director of training, Sarah Roy. She has had a few weeks to get acclimated and will continue to do so as there's a lot to learn here. She's currently fully immersed in the recruit class that started on Monday, and seems to be fitting in rather well for somebody that's brand new here and learning the chaos that we exist in every day. Moving on to the 121st recruit class that started Monday. We originally had 54 that were registered for this class. And then prior to day one starting, we were down to 48, which was as a result of a few people that their agencies had pulled, a couple of people that didn't meet the PT requirement. So we started the class with 48. If I'm off on my number, somebody will correct me, but I think we are down to 45 now. On day one, prior to lunch, we had a recruit that resigned. And then on Tuesday morning, we had 2 recruits resign. Both of those recruits were previous level 2 certified officers. And both of them just indicated that they were not fully prepared to participate in this class. I think it's important to note that we take great pains here trying to prepare folks from our perspective of what they're going to see when they get here. They have a recruit manual that's available to them. They have the PT prep plan that they can utilize before coming here. Their agencies that hire them, prepare them before they come here. We have orientation 3 weeks before the class starts that we go over everything ad nauseum. Visual depictions of what the day will look like. Make sure that everybody is on board, aware they're as prepared as they can be. And so when we have people that go through the first couple of days, it's a shame when we lose them, and we take great pains to make sure that those that are resigning have really thought that decision through, because they're not our employees. They're going to be leaving employment when they leave here, and that impacts them in ways that sometimes they don't think about. So we went through basically a 3-level process before people resigned. And so we've lost those 3, but everyone else seems to be doing well so far, other than managing some illness today and minor injury from day one. So we're moving on. Graduation will be scheduled for May 29th. Excuse me. Any questions on that update so far? Okay, not seeing any there. Yesterday, Lindsay and I made the trek to Montpelier to deliver our budget to House Appropriations. That was well received. We had some good conversation there. We actually also got to meet for the first time in person our Deputy Chief Financial Officer, Jason Pinard, who we meet with weekly by Teams. I've been here a little over 4 years now and have never met him in person. So that was the first opportunity that we had yesterday. So it was nice to meet him. Moving on to that, just a quick update from IADLIST in conversation, or excuse not conversation, but in communication with John Blum this past week. We are now at 21 topics that are completed, over 220 hours of content that has been revamped. And also note that we received some really excellent feedback on the current curriculum that we already had in place around DV prior. We also just got notification this week about the death investigation course that's put on here as an in-service training that came highly recommended and acclaimed based on the content that was delivered. I should point out that majority of that content is put together by the Department of Public Safety, mainly with VSP, Office of the Chief Medical Examiners, and some attorneys that are also part of that. So kudos to them for the work that they do in putting that together, and for our folks in hosting it and making sure that that takes place. Any questions on that piece? Not seeing any there. I'm going to touch on the last subject for my updates, which just was kind of a recent event. So I just want to make sure the council's aware. As you probably recall, over a year ago, we had this discussion about some reach out from Border Patrol regarding the training that we are required to provide for them so that they can be certified officers and work in conjunction with our state partners and, you know, the agencies that do work and interact with Border Patrol. We had to revamp what that training looked like because it was right in the midst of all of the FIP conversations and the fair and impartial policing policy being revamped. And we wanted to make sure that because that wasn't included in any part of that training, that we wanted to include a portion of that and make sure that there was an understanding about what Vermont officers are held to and the model policy. We did revamp that in December, I think it was, of 24. And then things just went by the wayside. We didn't have the request for the training, but that request has come up again as early as the end of last week. It sounds like there's about 31 agents that are going to need that certification. And I just want to remind folks that are on the council and any members of the public that have an interest in that is that this is a requirement of the council that we are required to provide training to federal law enforcement officers so that they can interact with Vermont and they have the ability to arrest for Vermont violations that take place. What has to happen first is that they have to complete a course of study that's approved by the Criminal Justice Council. Then they are actually certified by the Commissioner of Public Safety, and they take an oath that's administered by the Commissioner of Public Safety or her designee to uphold the Constitution of the United States of Vermont. And so we certify them by applying or by providing the training to them, and then they have to apply for that certification, and then they get that certification from the commissioner. What that does is it allows a certified federal law enforcement officer to make an arrest pursuant to Rule 3 of Vermont Rules of Criminal Procedure for violations of Vermont laws anywhere within the state that they determine is necessary, and how they determine it's necessary if it's to protect an individual in the presence of the officer from imminent serious bodily injury, to attack somebody else that might be in potential serious bodily injury circumstances, and to prevent the escape of any individual. So it's pretty small when you think of the concept of it, but in some people's minds it could be fairly large. This originally was to make sure that, as most people know, some folks that are Vermont certified law enforcement officers also belong to some task force where they're working with federal partners and they have authority to act under federal law. And this is kind of vice versa, but it also works for agents that are close to the border that act in a support role for backup officers for other agencies, or sometimes as the first responder. So it covers them to make arrests in that. So we are finishing up another revamping of that because we wanted to make sure that we have some testing to make sure that we're showing that the competencies have been met in what that training is. And then we'll set up a time to deliver that for the federal partners. So that's the end of that. I just wanted to see if there were any questions or inquiries about that update.
Chris, I had one, just a confirmation. I was skimming the Budget Adjustment Act and I believe I saw that the council's adjustment passed the House in that act. Do you have confirmation of that, or did I get that right?
We have heard that it has passed. I haven't seen anything in writing, and I don't particularly lean on anything that I don't see in writing. So every indication that we have gotten is that that has passed, but I don't have true confirmation about that yet. That satisfies me. Lindsay, do you have any other information on that?
Yesterday in testimony, they did confirm that they had approved it in House and it was at Senate.
Okay, that answers that. So that's good news that they went through at least that part of the process.
Yeah.
Are there any other questions for Chris from the floor? Okay, I think just an observation, it would sound to me that the numbers now at the academy are going to be a bit more manageable. I know that at the last meeting in particular, there was some concern about an extremely large class coming in relative to facilities and capability and instructional demand. I think that probably puts us into more normal numbers where the class is now. Is that accurate?
It does make it more manageable. 38 to 40 is ideal, but yes, where we're at now is certainly manageable and a lot more manageable than when we were first anticipating what we were going to have, which is usually the case. We usually get a larger number that's presented to us, and then through the first process and, the PT testing and the first couple of days of the first week, sometimes that eliminates some folks.
Thank you. I guess it's good from the instructional part of view and the logistical part of view, but it's never, it's never a good thing to have attrition up front like that. So, okay, thanks for that. Thanks for that update. If there are no further questions, we'll move on to the next agenda item. As the director spelled out the Essex County Sheriff's Department FIP policy. It's my understanding that Sheriff Colby wanted an opportunity to appear before the council and discuss his policy. It's also my understanding, very late, that there is no request to act today. So any action would either be delayed or postponed. So I will, if Sheriff Colby is present, I will invite him to the floor. I see him on the list, but I don't hear anything at the moment.
I see the sheriff on board and on camera now. I
Yes.
just don't hear him yet.
Okay. Yeah, we're dealing in a technical world that's less than perfect. So I know this happens I see the sheriff, but I can't hear him.
So he's disappeared. I'm assuming he's going to log off and try to log on
think it'll
again.
be a
I
reboot.
can.
We'll give him
I'll
a
just
minute.
preface while he's
Yeah, go
off
ahead.
camera. We provided the council with this agenda of just some of the latest policy review that the sheriff had submitted to us, as well as the feedback that he had received, written feedback from our attorney, Chris Burkett. This is after we've had a couple of back and forth on policy revisions and actually spent some time with the sheriff meeting in person to try to assist in the facilitation of getting a policy that both works for him and holds all of our important pieces of the policy together. So I believe that after the last feedback that the sheriff received, that he was going to be reworking and seemed to be in agreement of some of those recommendations that you saw in the draft response from Chris Burkett. But I don't want to speak for the sheriff, so that's just the last conversation that I had with him. So hopefully he'll be able to get back on here shortly and speak to the issues that he feels are important to his agency.
Thank you, Chris. I think what we can do while the sheriff is working on the technical items, our next agenda item is not extensive. And I think we can move to that draft policy VSA 2372, which is the sealed records update for an update from Counselor Chris Burkett. And Sheriff Colby, I think you can hear me. We'll come back to you. Let us know when you're on. And have the sound fixed. So let's move to draft policy 20 VSA 2372. Attorney Burkett, would you like to give us the update?
Happy to. Good morning, Chair, and good morning, Council. We sent the draft policy that we're required by Title 20, Section 2372 of Vermont statutes to create regarding the use by law enforcement agencies and the dissemination by law enforcement agencies of any sealed criminal history records. That was sent out in late December, early January to a host of law enforcement agencies for their review, as well as to the Department of Public Safety and the Vermont State Attorney's and Sheriff's Department. What we've heard back is some really good feedback, but what that feedback has given us is some need to look at revising the policy as it presently is written. The biggest concern is coming from really two areas, but one, the big one is with the Vermont Criminal Information Center, VCIC. And it surrounds how they disseminate law enforcement, specifically sealed law enforcement records to other law enforcement officers. And we want to make sure that we're creating a policy that is pragmatically possible for them to do. The policy as written right now would be problematic for them. So we need to look at that. And then I received some very good feedback from Tim Lueders-Dumont, the executive director from the Vermont Department of State Attorneys and Sheriffs, just this morning, that I want to analyze to determine whether or not it needs to make some changes. So that's a long way of saying that we're not ready today to give you a fully ready to vote on policy to give an up or down vote for, sir.
Thank you, Chris. And do you expect, well, I don't know, would it be reasonable that we might have that for vote at the next monthly meeting in March?
Yes.
Okay, good. Thank you. I'm going to check in with Sheriff Colby. We had any progress there? Let me see. No.
I'm not seeing him on. I did send him over the call-in number, but I haven't seen him come on with that either.
This item is fairly substantial in some respects, and I'm a little reluctant to jump. Why don't we give the sheriff another couple of minutes, and if not, I think we need to proceed with the agenda. So while we're doing that, does anybody have any updates from their agencies or events that you'd like to share with the larger council? Things that are happening that might be of interest? Okay.
You have me now.
Wait. I see the sheriff. I see his name.
I think you have me now.
There we
Okay,
go.
you're there. Okay, we got you. Sorry for the technical difficulties.
No issue. I apologize. So thank you for the opportunity to come talk about where we're at with FIP. I think that the most reasonable way to approach this for me is to look at the letter that I've gotten in response to our last policy draft. And before the meeting, I had actually said to, I sent an additional revised policy in subject to the draft, and Director Brickell said there's just not enough time to implement my acceptance of the recommendations that were made by council. This has been quite a long and frustrating process. However, in the letter that they sent, they talked about section 1, the language where I, in my frustration, was calling out the council and the legislature on the policy, and I stated I'm fine to strike that language. Under number 2, the language included the definition from federal regulation for alien, because there's language in there related to the statutes that are titled alien. I put that in. I'm also fine to strike that. This is not any language I want in my policy. It's more of a reaction that I've had to what the council has responded, or the council staff have responded. Section 3, I put in an entire section on the federal criminal laws that we would be responding to, because one of the arguments and debates that I've been having with individual council members was the difference between criminal and federal policy. And so the reason I've tried to put that in our policy is so that our officers understand what they can legally enforce versus what they cannot legally enforce. And that's not something that is in the policy anywhere and really talks about what we can do. It only talks about what we can't do. So section 3, I'm fine. And I said I'm happy to strike the language that talks about conspiracy because the other sections are already in there. So under number 4, the reason I'm back here with the council is this is one of the sections that I feel like really oversteps the ability for law enforcement to do their job by putting a restriction on us. And so there's 2 sections of language in this area that's written in the policy. And one is establishing a reasonable suspicion, and the other is sufficient to warrant an investigation. And so my problem with this language is one or the other is appropriate. Both are not. So really, when you start getting into the way this policy is created, it's one thing to say that proximity to the border does not establish reasonable suspicion. However, it's a whole nother thing to say that doesn't warrant any further investigation. That limits an officer from seeing somebody that's literally crossing the border from going back and investigating a criminal activity. And so that is one of the areas that I'm asking the council to look at, because the way the language from the legislature reads, it talks about increased communication with federal officers, but it also talks about the essential elements of the policy. To me, the council could clearly state that one or the other isn't required, proximity to the border or sufficient to warrant an investigation. That's where I'm hung up, is on the sufficient to warrant an investigation. I feel like the council's policy goes beyond stating criminal or civil, and what they're talking about is limiting a criminal investigation. And that is one section that I'd like the council to focus on, because that's one of the areas of disagreement that we couldn't get past in the meeting that I had with both attorneys from the council and from the Attorney General's office when we went to review this. And so that's the one place where in section on item 4, the language that I still feel like I should be allowed to amend is the language that states sufficient to warrant an investigation. I suggested initially removing proximity to the border, but sufficient to warrant an investigation would work equally, because both of the arguments from both attorneys only talk about establishing reasonable suspicion, which I'm fine with, that proximity to the border doesn't establish reasonable suspicion. However, when does an investigation start? When I see somebody in the tree line and I hit my brakes and I back up to go check them out, and I go to have a conversation with somebody where I'm not detaining them with my blue lights on, that is just building information to be able to establish the reasonable suspicion. And I believe that the language cuts that ability out for Vermont law enforcement. So that's number 4. Number 5, that language is directly from the federal regulation language that's included in a lower section. And so in this section, the issue raised where I added the language possible commission of a federal crime, that actually comes directly from the federal regulation that says people are not supposed to restrict communications about possible commission of a crime. So I don't know why the council would attempt to restrict that language if it's already in a federal regulation. Then number 6, under 6A, the suggestion that I remove all of that language from the statute, I'm fine to remove that language if we can get to a point where the policy doesn't seem to be fitting that language. So again, if we are able to come to an agreement and remove some of these sections that are limitations, then it makes sense to me to be able to take that language out. I don't need it if we end up modifying some of the other sections. Number 6, number 7, I mean, sorry. This is a new complication that was raised after meeting with council in this letter. It's the first time I've seen it, where if I make a stop and I detain someone and I want to reach out because it's a matter of public safety and it fits all the profiles, that somehow we would not be able to detain someone until the federal authorities get there without a judicial warrant. That's council language that's been put in that was new to me and not a way that I interpreted the policy. And so that I will leave back with the council to kind of consider. My language was simple. I was actually just asking or stating that those rules didn't apply to persons arrested or detained for a federal criminal offense and are being detained until appropriate federal charging agency is present and available to complete the investigation, arrest, or provide a criminal citation. What you're saying is if there's a federal violation, a federal crime that's been committed and we observe it and we stop someone for it, that we can't turn them over to the federal government to complete that without a judicial warrant. That's what's been raised in the letter. The Section 8 is probably one of my larger issues, and now, other than the sufficient to warrant the investigation, Section 8, if you look at that, when you go through all the things that we can and can't talk with the federal agencies about, the way that 8 is written, every time you want to communicate even a crime that's been committed that fits the communication language, you still have to contact a supervisor every single time. And that means if an officer's got an active situation happening and wants to put a BOL out, the officer on the road can't say, hey, contact Border Patrol, this vehicle is headed in this direction, this person is headed in this direction, without contacting a supervisor. And to me, that is a restriction on all officers that I don't know whether all officers interpret that in the same way, but that's clearly the way that I view that it's written. And so that's why under Section 7, I wrote whenever an officer is unsure if the information being released would violate policy, so that it opens the door for them not to have to contact a supervisor to be able to relay information about an active ongoing issue. If you need me to detail that a little bit more specifically, I can. It's under Section 7, and let me go back to my phone. So under subsection D, the original of the additional restrictions where it says shall not, after that section where it talks about shall not share any information other than citizen and immigration about an individual with federal immigration authority unless there's justifications of these grounds. Well, you would assume that language means once you are justified under those grounds, you can communicate. The very next line says, prior to providing such information, agency members shall consult with a supervisor if available. That's really unrealistic for me when I'm the only supervisor in my department. So does that mean that every officer has to try to contact me every single time they want to put a BOL out, every single time Border Patrol's reacting for backup? Those types of situations go beyond what I believe are appropriate restrictions within the policy. And then finally, number 9 in their letter is the I'm fine with the recommendations in the letter. The problem is, I don't know if the recommendations that have been made in the letter and the things that we've already agreed upon or have found to be appropriate and not violate the policy would be approved by this council. because there's language that's been removed, adapted, and changed that I don't know whether the council is going to have an issue with or not. I actually thought that this meeting was going to be a meeting where you were voting. And that's part of the final issue that I will state is this has been an exhaustive process without any real clear direction.
Synthetic 7-OH, a new opioid that's showing up, and we're working with the DOJ on addressing that because chemists are coming up with new opioids faster than the government has been able to keep up.
Okay, sorry about that.
So as we've been working through this, there are areas that are, to me, are not requirements or don't create more communication than the policy allows, other than under Section 8, where there's a requirement to go through a supervisor for any communication about any issue with Border Patrol. That's one of the areas that I believe that there's a barrier.
Sheriff, do you have some more? We can open up the floor.
No, that's fine.
Okay, thank you. Well, it looks like, I know it may not feel like it, but it looks like there is some pretty significant process. I appreciate the fact that, it does seem to be taking time. Maybe a little more than we might like. But again, some progress. My understanding, and perhaps Councilor Burkett can help with this. You mentioned that there has been a revision based maybe on some of this interaction. That there is another version. Is that the case? But it hasn't had time to be fully reviewed.
The issue is the reason I submitted that is to limit the number of conversations, but there are 3 or 4 items that will continue to be disputed, which is until the council makes a decision.
Okay. Karen Scott, you have the floor.
Thank you so much. Thank you very much, Chair Clemens. Just a question for Chris, for Director Brickell. I want to make sure that I understand this correctly, that we're over a year into the adoption and implementation of this policy as was written and vetted by the top law enforcement officer in our state, the Attorney General, and that every other jurisdiction in our state has adopted the policy. Do I have that right?
Almost correct. Every other agency has, with the exception of 3 that we're still working with, and that's not through lack of trying. One that we're still working with has adopted our policy, but they have another policy that governs their entire employee structure, not just their law enforcement. So we're working through the logistics of that. The one where we're still working with Richmond and Heinsberg together, because of the fact that they kind of work jointly and they had different ones. So we're working through those logistics. Other than that, and some technicality with DMV, yes, that's where we're at.
Thank you.
Thank you, Karen. Do we have any other comments or observations?
I'd like to just, I guess, maybe just observations in that, sometimes this is an extremely long period of time that we're going on in order to get a policy that works for the sheriff. And in those cases, because of that, that's why the statute reads that, until such time that they get it, that they have to adopt and fully implement the council's policy until such time as we get there. And the sheriff, is well aware of that as well. There are many things that occur here on a daily basis other than just this one topic, which is why sometimes that communication flow goes off for a month or 2 because legal on our end is, working on several other things. And to Sheriff Colby's predicament, he doesn't have just a legal person he can go to and try to resolve those issues. Again, we are always going to try to work in collaboration with agencies statewide to try to come to some reckoning. But I think we're at a point like we've tried to do what we can to get the sheriff's policy in compliance with either the council policy or potentially suggest some language that might work for what his specific need is in his area. But if we can't, we can't. There comes a point when we have to just say, we are working in the spirit of the statute and trying to get to that agreement. But I guess sometimes I get a little bit, I want to say frustrated because that's not the right word, but when I hear Sheriff Colby bring up these things about that he's not happy with the language in the council policy, or why we can't use the language that's in federal law or in their policy because it's already in federal law. That ship has sailed. We had, plenty of meetings for law enforcement to attend when the FIP subcommittee was having all these. Many agencies did, and I recognize that sometimes they just don't work for individual agencies. They've got other responsibilities to do, but you got to keep tabs on what's going on in those committees if you know that you have a very specific need for your prospective community or the area in which you police. So I guess I'm kind of at a loss of where we go from this point. We're going to continue to work with the sheriff. And as he said, he just sent another review, which was after we had sent out all of the documentation about his last policy and the response that he got from our attorney that was in conjunction with Julio Thompson from the AG's office. So we will, again, take a look at that one as quickly as possible and see where he's made those changes. And then my guess is we're going to come back again to some issue of stalemate on some topics, and then the council's just going to have to decide where we go from there.
Okay, thank you, Chris. I guess that would parallel my observation, because what I see then and what we would need to see as a council, I know I'm not prepared to see the latest clean version. Sheriff Colby, I appreciate that you looked at that correspondence from Attorney Burkett and are willing to incorporate or make a number of those changes, actually a good number of those changes that were recommended in that. But I think that needs to be in that cleaner policy, the newest version of the policy. And I think the council would need to see at least the Academy's review of that cleanest version before we would move, because we would be ultimately looking at a Rule 9 waiver. I think that's what you're asking. If it's not in compliance, does the council wish to waive the requirement? But I don't think we're in a position today to do that. We have two questions up here. I'm going to turn to Karen Transgard Scott first.
Thank you, Chair. A point of process. This policy began with the Fair and Impartial Policing Subcommittee. I hope that any changes to the policy start with a review by the Fair and Impartial Policing Subcommittee, and that we include the Attorney General's office in any kind of possible change that we would make to this policy.
Yes,
I also,
yes.
Sorry, Bill.
No, I said I agree.
Also, Sheriff Colby, you began your presentation with reference to some things that you had put in writing out of frustration. I'm hoping that you're retracting your threat to sue anybody who voted in favor of the Fair and Impartial Policing policy. Is that true?
I don't think that's an appropriate question for the council. So first of all, if I decide to forward this, I've already expressed, I don't intend to sue, but I'm actually, if we don't get through this, my next step would probably be to refer it to DOJ. That's really where I'm sitting, because I feel like the restrictions the council has placed. So I didn't want to get into the back and forth, but that seems like where you want to go. So the first time I submitted this, I had a different response from your first attorney than I have in your second attorney. The first response didn't exclude the language of should not investigate the criminal violations of re-entry or entry into the country illegally. Now, your second counsel said, oh, that's only a recommendation, it's not a requirement. So they've already removed that from this forwarded policy saying, oh, that's only a recommendation, not a requirement. So we can exclude that language. And so I feel like the state of Vermont law enforcement officers have been duped by the language put in place by the council where it said should not versus shall not. I don't think that that's appropriate. And so that's where you get into the finer lines of what this policy originally stated. And I'm trying not to go there with my frustrations, which have been trying to get the point to where the council votes, because I'm trying to work with Chris and we went, and in that very first beginning of the meeting, I felt like some of the language I got back from the council was inappropriate and kind of snarky. And so I decided to go into this meeting openly, and we had a great day. We had a great day discussing this policy and trying to get through the issues within this policy. And that was productive, but it comes down to exactly what was said before. There are certain areas that I believe that are restrictions that should not be on Vermont law enforcement that cross the line from civil and enter into the world of criminal. And that's all I'm trying to clarify. I'm not trying to do more. I'm not trying to change anything. I'm just trying to get the council to look at the policy that was originally created and look at those revisions that restrict us. That's all I'm trying to do. No, I don't want to sue the council. And no, I don't want to sue the individuals on the council, period.
Thank you, Sheriff Colby.
All right, thank you. Chris Burkett, you had your hand up, now you don't? I just want to make sure that I didn't neglect you.
That's fine. And thank you, Chair. So I would agree with your assessment that what Sheriff Colby is essentially asking for here is a waiver to rule, which our rules permit him to get. It would have to go through, I believe, the waiver committee prior to the full council. And so I think it would be appropriate to assign this to the waiver committee for their next meeting. To the extent that he is requesting a wholesale change to the model policy, my understanding, and I believe I saw Ms. Ryan on, who is our Academy representative contact person for the Fair and Impartial Policing Subcommittee, and so she may be able to speak to this more than I can. But it's my understanding that this was the biennium in which the policy was under review, that there was an opportunity for open discussion regarding any modifications or revisions that could be made, that the subcommittee heard those individuals, and ultimately they voted no changes to the policy as it currently stands. So the policy is what the policy is. It's not to say that the subcommittee can't meet and revise it before the next biennium, but it has recently met and it has made the decisions made. So what Sheriff Colby essentially is asking for, if I understand, is a waiver of rule based on his disagreement with a couple parts of the Fair and Impartial Policing policy. Specifically, I'm hearing him say Section 5, subsection C, which is the part regarding reasonable suspicion of criminal offenses in proximity to the border. It sounds like we're not going to be able to find language that is going to be both effective for him and within policy for that. So given that representation made today, it would be my recommendation that the council refer this matter to the waiver subcommittee.
Okay, I would concur. That was the essence of my comments a moment ago about having the most recent draft in order and then to put it through that process, because it is a waiver request that we're not procedurally or substantively prepared to make a definitive decision on today. So if we do that process, then I think we would be situated soon, next meeting or so, to have that activity and to take that action or not take that action by assessment of the council. So I think that's where we are. So Sheriff Colby, you'd mentioned that you had made some revisions and had sent them in. That's correct? The latest revisions?
I'll make a couple more.
Okay, then we would certainly welcome that. And again, as Councilor Paquette pointed out, we did go through the 2-year biennial review of the policy, for which there were several public opportunities, various opportunities to submit to the FIP policy changes that might be required at that level through that committee. That is a dynamic process, and so if there are again recommendations specifically that could go to that committee to be discussed, that's another avenue. That doesn't alleviate the issue of the waiver request. That's a separate issue, but there is a dynamic process that would allow for that information to be assessed. So, okay, any other comments, questions, observations? We have the sheriff or anything while we have him? Yeah, I think we've outlined a plan, at least the next steps for the short term to move toward. I think what you would like to see happen, Sheriff. And we may get there. Maybe we'll reach some agreement. I'm not sure. Thank you for coming and resolving the technical issues.
Thank you. Have a good day.
Okay, thank you. Moving on to the agenda, our last major item, the potential suspension of law enforcement certification for Ryan P. Palmer. I'm going to turn the floor to Councilor Paquette to introduce the subjects.
Thank you, Chair. After the revelation last week of criminal charges brought against Sheriff Ryan Palmer, the Professional Regulation Subcommittee of the Criminal Justice Council met in emergency session, during which time they reviewed documents that were in the public eye. These are the criminal information filed by the state's attorney and the supporting affidavit of probable cause. They voted unanimously to send under their procedure 7.1, which I will share on my screen. Hopefully, if I get the technology to work. Our policy 7.1 is to request a special meeting of the council. As it turns out, we are having a regular meeting of the council today. So instead, they requested that this action item be added to our agenda. And they also voted unanimously to recommend that the council order summary suspension of Sheriff Palmer's law enforcement certification pending a hearing under Title III, Section 814, sub C. I'll stop sharing so that if we need to, I can bring that up and show you that legal language. So it is for that reason that the subcommittee, and I believe the chair of the subcommittee is present. I know that the vice chair of the subcommittee is present. They are here recommending that this council take action to summarily and temporarily suspend the law enforcement certification of Ryan Palmer.
Okay. Any observations before I'm going to ask that we go into executive session?
Yes, I apologize, Chair. There was one last thing that I did need to bring to the council's attention. Yesterday evening, we received a voicemail message from Dan Seaton. He is the criminal defense attorney for Mr. Palmer, and I was able to speak directly with him this morning. And I am authorized to state that he was authorized to state that Mr. Palmer does not oppose a temporary suspension of his law enforcement certification while the criminal matter is pending.
Thank you very much. And with that, I will entertain a motion to go into executive session for the purpose of considering a matter of clear and imminent peril to the public safety, and to communicate with and receive confidential legal advice on this issue, where premature public knowledge would either place counsel or Mr. Palmer at substantial disadvantage. And invite Executive Director McKell, Deputy Director Hawkins, and Director of Administration Diverge, as well as Counselor Burkett, to attend those information that may be needed to reach our conclusion. Do I have somebody wishing to forward that motion that I just read? Sheriff Anderson.
Mr. Chair, this may be a point of order. I'd just like to have a brief discussion regarding potential or perceived conflict of interest. Obviously, Sheriff Palmer is a sheriff. I do not believe that I do have any conflicts of interest, but given the nature of how sheriffs are formed in Vermont, I at least wanted to welcome an opportunity if anyone felt concerned with me participating in this conversation, that we have that dialogue. I'm happy to speak as openly as I can, but again, I do not feel that there's any conflict of interest, that I could vote on this of free will and accord without any duress or concern.
Thank you, Sheriff Anderson, for bringing that up. That is important. But anybody have any questions or concerns given what Sheriff Anderson just noted? Okay.
Mr. Chairman, if I could be heard.
Yes, sir.
My name's Mike
Yes,
Donahue from Vermont News First. I guess I have a question
Yes.
as to why you need to go into executive session when the council has clearly said that there's no contention here, that the Sheriff Palmer has said that he's willing to forego. And so I'm not sure it complies or comes under the reasons to have an executive session when in fact everything is going to be on the table supposedly.
Dealing with a matter, there may be other information as well. And Executive Director Burkell, do you have a comment?
I do, Chair. Just as a sort of a response to Mr. Donahue, in that, while from what I heard from Attorney Burkett, there is no issue with the sheriff potentially surrendering his law enforcement certification temporarily. What that language looks like, or what the council may decide for the language on what that looks like, might be a point of discussion for the council to have, rather than just the verbal communication. So I would think that there would need to be some legal guidance on what a finding of this council might be as a result of that proceeding, if there was such one. I'm no attorney, though.
And I guess I would contend that could be done in open session, much like when you're crafting any motion that people wordsmith motions all the time.
Yeah, this is beyond just a general motion. This deals with personnel. This deals with a sensitive matter relative to what ultimately, even though temporary, ultimately has some significant implications. So unless
could you show me where in the law? Could you show me where in the law sensitive nature is that term is used for executive sessions? I'm unaware of that.
I'll turn to Attorney Burkett.
Point of order, Mr. Chair. Doesn't the council have a right to consult with its legal counsel in executive session?
Yes, it does. That's exactly what we're doing. So
I don't know that I have the language, but Mr. Chair, I'm willing to make a motion. We enter an executive session with the people you listed for the purposes of discussing information with the council's attorney, which I believe is a qualified reason under the public or open meeting law for an executive session. Would that satisfy the needs of the council?
So moved. Do we have a second to that motion?
I'll second.
Okay, it's seconded. All those in favor of going to executive session, Lindsay, we're going to have a count. Those that are qualified. That's just a reminder, Attorney Burkett put this up, that we need a 2/3 vote to go into executive session. And the technology so it can be documented. Reminder for those council members, as you have been doing, to vote in the chat if you're not on the secure system.
That's 15, yes.
Okay, so we have the 2/3 majority. We will enter executive session. Lindsay has prepared a link. Remind us how we get that again? Is it in the calendar?
I have sent it to everyone's mail. Mark just started it, so anybody who has the link, you can join that. It should pop up on your screen.
Yep, it's there. Okay, see everybody there. Lindsay, let me know when we got folks back. Technology can be a problem at times. It looks like folks are coming back in. Okay. Seeing people. Okay. I think we got most people back.
Yes, we are all set.
We're all back. Okay, we are back in public session after consulting with legal counsel on this matter. And I will turn the floor over to legal counsel to present the action of the council.
Thank you, Chair. I'll share my screen. This time, we're asking that the council consider, sorry, I'm getting a echo. The following order for temporary suspension, and it reads as follows. Whereas pursuant to PRS procedure 7.1, the council convened upon the request of the Professional Regulations Subcommittee. Whereas the council has considered the allegations contained in State versus Ryan Palmer, docket number 26-CR-00963. Whereas the allegations contained in the publicly available documents describe a concerning course of conduct that victimized 2 women, including following and encountering these women in his official police cruiser and using his position of authority sheriff. Whereas the allegations include several felony crimes, specifically aggravated stalking with a deadly weapon in violation of 13 VSA section 1063A5, lewd and lascivious conduct in violation of 13 VSA 2601, and obstruction of justice in violation of 13 VSA section 3015, for which probable cause has been found by a court of competent jurisdiction. Whereas these allegations, if true, constitute a danger to public health, safety, or welfare that imperatively requires emergency action, and whereas as the elected sheriff, there is no other mechanism available that can restrain or limit the law enforcement actions of Ryan Palmer during the pendency of the instant criminal charges as would be available in other agencies or for other officers not elected to the position. Therefore, the council hereby orders the following. Ryan P. Palmer's law enforcement certification shall be suspended pursuant to Title 20 VSA Section 2405 and Title 3 VSA Section 814 until further proceedings on this matter can be held as soon as practicable. So ordered this day.
Thank you, Chris. I will entertain Sheriff Anderson.
Mr. Chair, I make a motion to approve the temporary suspension order as drafted.
We have a motion. Kelly,
I'll second.
seconded by Kelly Purpore. Any further discussion on the matter and the motion presented? Okay, hearing none. We will vote. Lindsay, I think we can vote through the normal process as long as we're recorded. I've lost Lindsay. Oh, there she is.
Sorry, no, I'm right here.
Too
Sorry,
many
did
people
you
on the screen.
roll call or poll?
Well, let's do it through roll call, please. Yeah, I'm sorry, I didn't clarify. I
No,
was
that's
thinking of
okay.
that as what we use in actions like this.
Okay, perfect. Leslie Johnson,
A reminder, a yes is to support the motion, a no is not to support the motion.
and I apologize, I don't have everyone on one screen, so if you do accept, I don't see her on here anymore, but if you do accept, can you please
Okay.
just come on screen and make sure that you're verbally responding? I'll come back for Leslie, but Daniel Guerra,
Yes.
David Peterson,
Yes.
Glenn Boyd,
Yes.
Matt Nesto,
Yes.
Jenna Reed,
Yes.
Heather Sinkowitz,
Yes.
Domenica Padula,
Yes.
Tim Lueders Dumont,
Yes.
Tom Chinette,
Yes.
James Pomprion,
Yes.
Mark Anderson,
Yes.
Trevor Whipple,
Yes.
Sadie Donovan,
Yes.
Kelly Papour,
Yes.
Karen Transgard Scott,
Yes.
and one more time, Leslie Johnson, although I believe I just got an email. She's trying to rejoin. We do have a all affirmative on that vote.
We'll consider the motion has passed unanimously and will be communicated as per normal procedures to Sheriff Palmer. Are there any other items of business on our last agenda item for general discussion or further items of business? I have none other than to remind folks that keep that hearing date on the 17th open as that develops. Also, it's never too early to mark May 29th on your calendar for the next Academy class graduation. We've had good turnout in past graduations, and the May is a nice time to be on the Academy. So, any announcements for the good of the order? Any items folks want to share? Okay, hearing none, I will entertain a motion to adjourn.
So moved.
So moved. I'll second.
Okay, I'm going to say moved by Sheriff Anderson, seconded by Karen Transgard Scott. All of those in favor, quick hand up by acclaim. The meeting is now adjourned, and we will reconvene on February 17th as scheduled. Thank you.